So one client who I spoke with recently had an interesting situation. So he filed for NIW, which was approved, but the issue is that he also has had a pending asylum application that he filed with USCIS quite a while ago. I mean, we're talking almost 10 years ago. So he had two different attorneys handling each application, one for the NIW, one for the asylum. And then the whole question was, can he adjust with an approved I-140 in the NIW category? But also there is an asylum that was lodged 10 years ago. The interesting thing is, um, guess what? USCIS just recently scheduled a client for an asylum interview, and it's coming up very soon. So that was his question is what's going to happen? Um, it was kind of a complicated consultation because, there were multiple attorneys handling parts of the client's cases. And, you know, it's kind of like, what is the left hand doing? What is the right hand doing? And do they both fully know what is going on with each of the individual cases? The other issue was that this client was not currently in a valid temporary status. So that is also a wrinkle to sort out. A few things that I advise the client are that, um, you know, if you have an approved employment petition, um, either a labor certification or an I-140, generally, in order to be eligible to adjust status to permanent residence, you have to be maintaining valid non-immigrant status um, up until the time that you're eligible to file for adjustment. So you can only file an adjustment when a visa number is available. So, um, based on the visa bulletin, based on the employment preference category, and also based on the client's country of chargeability, meaning what country were they born in, they are subject to that particular um, quota, right? So if the client is not currently maintaining status, which he was not, he initially entered on a visa and then overstayed, then that is the first red flag, right? I didn't see how the client could be eligible to adjust status if they had overstayed their visa quite a while ago. And the fact that he may have filed an asylum application within the 1 year deadline of filing, um, that in itself does not toll the time, or it does not give him any kind of exemption from this requirement to maintain valid non-immigrant status. So my takeaway to the client was, I don't think that you can file an adjustment based on the approved I-140. Um, and the other issue was what to do with this upcoming asylum interview. Well, it would really depend on how strong the asylum application is, because you have to think about what could happen after the interview. If it's a strong claim, or at least decent, then my advice to the client was you should attend. Because if you don't attend, that could raise questions to USCIS. They may wonder, why are you backing out of this application now? Um, so because I didn't file the asylum, I couldn't really um, review the merits of the asylum application. But assuming that it was a non-frivolous, um, meritorious application, then my advice to the client was to go forward with the asylum. Best case scenario is it's approved. So if it's approved, then that is the best and the ideal outcome, because if immigration approves an asylum application, then you get the status of asylee. Being an asylee is a status, regardless of whether or not you overstayed your previous visa, if that's how you enter the US, or even if you enter the United States without inspection, meaning without permission, if you're later approved for asylum, then that initial entry does not become a bar to you being able to adjust status to permanent residence. Um, Clients who are granted asylum can apply for adjustment after being an asylee for 1 year. So that to me was the best possible outcome for this client's case, is he attends the asylum interview, the asylum officer finds the client eligible to receive asylum, is granted, and then waits 1 year to adjust status. If the asylum officer cannot grant or does not find that the case deserves a grant of asylum, then what will happen next is if that client is not presently in status, then technically the asylum office will refer him to removal proceedings, meaning immigration court deportation. So if that happens, then the client has another chance at the asylum application. They can request the immigration judge to review their asylum application de novo, which basically means all over again. The asylum office does not actually deny asylum applications. If they can't approve it, then they will refer the client to immigration court if that client is removable, meaning they're not in a, valid status at the moment. So that is not the, you know, although it's not ideal, it's not the worst outcome. They at least have the chance to have an immigration judge review the asylum application. Um, so not a straightforward case, but I'm hoping that that client does get a favorable outcome at the asylum interview. We also kind of talked about, okay, what happens if the asylum is not a viable option, if it can't be, it ultimately doesn't get approved, and what to do with the approved I-140. I mean, there's a outside chance that the client could look into consular processing, meaning applying for an immigrant visa at the consulate abroad in the home country, but then he'd need to review with his attorneys um, what are the consequences and the risks he would face if he were to leave the US. Because if you leave the US after accruing unlawful presence, then the moment you leave the US, you trigger either the 3 or 10 year bar of unlawful presence, depending on how many days someone has been out of status. So that's something to think about. If he does decide to leave the US, then he would trigger the bars to unlawful presence, and then he may have to look into applying for a waiver of unlawful presence from abroad. If the waiver is approved, then he may be able to apply for the immigrant visa. But that's something that, obviously is not a guarantee, and he has to take into consideration what the risks are of departing the United States. So that's one consultation. Another interesting consultation I had recently was for a client who applied for a student visa at the US Embassy in his home country, and he was refused the visa under 214B grounds. So 214B basically is the most common reason why a US embassy will refuse to issue a temporary visa to someone, and that is because they think that that person has immigrant intent. So non-immigrant visas are temporary visas, and these include student visas. And one of the requirements for applicants is that they have to demonstrate that they don't have so-called immigrant intent. What is immigrant intent? That means an intent to immigrate to the US, or basically um, the intent to live in the US for long term. So they made this finding, and the client was completely confused and did not understand why the embassy made that finding. So at the consultation, I broke down everything that happened at the interview. Um, and I also asked the client a lot of background information about all of his family members, who lives in the US, who lives outside the US. For all the family members that are here in the US, what immigration status are they in? How long have they lived here? Who are the family members that are living abroad? What do they do abroad? How long have they lived abroad? Have they ever visited the US? Um, I did quite a thorough screening because I think that the answers that I got from the clients to my questions really kind of made it clear what the thinking behind the embassy's decision was. So based on how my clients answered the questions, um, I came to the conclusion that the reason why the embassy refused to issue him a student visa is because he already had family members here in the US who similarly came to the US to study and also to work. Not only that, but the family members who were here have been here for a number of years. Um, those weren't the only questions that the officer asked at the interview, but that was the crux of it. They seemed to be concerned that there were other family members who were in the US who had been living and either working or studying in the US for a number of years and who had no intention of leaving the US anytime soon. Um, and I think it was after eliciting this information from the client that he started to come around and understand, oh, I see. That's the reason why the embassy wouldn't issue me a student visa. It's because of the fact that there were other ties, family ties that were here in the US, that were kind of on the long-term side that led to the officer finding that this client um, was found to have immigrant intent or potential immigrant intent. So it's unfortunate because once the embassy makes a 214B finding, there's not a lot that you can do. So one of the questions that the client asked me is, well, can I apply right away and ask for a reconsideration? And my general advice is that's usually not a good idea because if you apply right away, although there's nothing banning you from applying again, what are the chances that the embassy will come to a different decision, right? Unless the facts in your case have substantially changed, I don't see them changing their mind. In fact, I've consulted with clients in the past who did this exact thing. They were refused under 214B and they applied a month later. Nothing has changed. Um, Not surprisingly, the embassy denied the visa again and said, come back in, X number of years, right? When things have changed. So, um, the embassies really have a lot of discretion in making this finding, whether or not someone has established that they have enough ties, to their home country so that they will not be likely to remain in the US past their non-immigrant visa, right? I think from the embassy's perspective, they are always on the lookout and they're concerned that if they issue someone a visa, such as F1, then the typical pattern is that once the client graduates, then they are going to try to look for a sponsor, a company to sponsor them for a work visa, and then eventually a green card. So I'm not justifying that this is the correct analysis, but this is kind of the reason behind a lot of these 214B visa denials is that they think, well, you only really wanted a student visa so that you can get your foot in the door to eventually establish a pathway to permanently reside in the US. Um, so, 214B, very hard to overcome. Also, decisions from consulates, uh, very difficult to challenge, right? There's this thing called doctrine of consular non-reviewability, which basically gives a lot of Um, basically, it's this doctrine that says that you can't really appeal a consular officer's decision. You can't sue them and say, have a court force them to issue a visa. Um, and I think the general rationale for that is that, the consulates have to take certain things into consideration in deciding whether or not to issue someone a visa. They have to think about national security and other, so-called concerns. So this is kind of a big obstacle. If an embassy decides not to issue someone a visa, it's usually an uphill battle to try to, get the embassy to change their mind and issue a visa.